understand them, and because I haven't heard the entirety of the case or anything.
Right, exactly.
I'm
Probable cause or anything.
going to deny your request. Bond, continue.
Why?
Excuse me? Excuse me? Sir, we're going to have a real problem if you're going to act like that in this court. I want to make it real clear. I understand you want to represent yourself. I told you I'm going to hold you to the same standards. You will not, by motion, by anything you say, disrespect anything in this court. You understand me? If there is another outburst during any of these proceedings like that in regard to my rulings, I will give you a place to stay. You do not have to worry about having a tether. Am I clear? Am I clear?
Sure.
That concludes bond violation hearing, April 16th, 2024 at 2 p.m. At 2 p.m. There anything further, sir?
With the bond, yeah, that'll all be discussed as part of the tether division. Because this time, this will be 10 days, it'll be like 15 days, and by the time that happens, I was hoping that would count for something, as far as the conditions of my bond. Maybe I can't afford cash bonds or something, just write a beer out on it, maybe sign that guy, you know.
I don't know what you're asking me.
If the tether situation could be addressed on the same day.
I'm going to address everything on any day that you appear. So if the tether is part of the condition of your bond, which at this point you're in violation of, I've set a hearing for the 16th to determine whether or not there was a violation. But the allegations are there that there was a violation. The following week, you're set for preliminary examination on the charges. Okay, so all right. I'm going to assume that there's nothing else. Bond will remain revoked. You wanted to argue your bond, sir, given the violations. How can you assure the court that you will abide by the conditions that have been set?
Just the fact that I'm a law-abiding citizen, besides the fact that I'm guilty of this, no proof that I haven't been convicted guilty of this. Besides this, goes ongoingly, I'm a law-abiding citizen, so I guess that for being considered innocent.
Sir, you are considered innocent until proven guilty, but the court also has the ability to set your bond and give conditions. All right. The court initially did that, and you violated those conditions.
Yeah, no, I understand what you're. I think it's a lot. I do my best when I get out. That's when I get out. I'm a law-abiding citizen. I don't.
It's 2 events that he's back at the library. So on when I was speaking with office beforehand, they made that abundantly clear to me.
That there were 2 times that he was,
yeah, then at 2 separate libraries.
So there's this filter thing, and we're trying to figure out where it comes from. We'll sort that out. But the balloons are pretty, I bet. They were. Okay.
So it's 2 April 3rd at 5:55 p.m. He was there. He was looking at according to the police report, he was looking at pornography at a public computer that he was suspected of masturbating. I asked the officer who's here to give me additional details about that. And I believe the information I got was that the witnesses believed he was masturbating, perhaps that his pants were in a certain position, that he was rubbing his genitalia underneath his clothes. which is similar to the events of the April 5th in the sense that when the police get there, he's not actually exposed, but certainly conducting himself in a way where he's got his chest exposed, his outer layer of pants pulled down. And this is a CSC case. So it's like when we take that behavior and then we layer it on with the fact that he's out on bond for assaulting nurses at the U of M hospital, and he's now charged with CSC for his sexual assaults on them. But in response to the I'm a law-abiding citizen, I mean, I'm looking at his criminal history from Florida. I'm looking at his criminal history from North Carolina. I'm looking at his criminal history from Michigan. The majority of what I'm seeing are misdemeanors, but I do have carrying a concealed weapon from North Carolina. There are larceny offenses from North Carolina. And
No, there aren't.
well, there are. I'm not looking at them right now.
Sir, hold on. I will. The bond violation has been found, and the defendant's bond will continue as revoked. You were set for, I will review that again, but you're set for preliminary examination in this matter this upcoming Tuesday, the 23rd, so a week from today. Pardon?
Do my bond on that day.
I will look at it after I hear testimony in the case. But at this point, your bond will continue as revoked. Thank you. The court does call the case of the People's State of Michigan versus Cody Lee Jolly.
Andrew Childers appearing on behalf of the people, Your Honor.
All right. And this is the date that has been set for preliminary examination. Mr. Jolly, you are there. Would you like to participate in this preliminary examination, sir? You are still entitled to do so. Okay, very good. Okay, I see the jury, and I was just about to mention what you sent me. But right now, we're not at that stage. So what I'm trying to ask you is, do you want to participate in this proceeding today? You do. Okay. So you may have some questions yourself for the witness. You're muted at this time. Let me see if they can unmute you. Can you hear me, Mr. Jolly? Okay, so you might have some questions yourself. Okay. Okay, so we're going to go ahead with the preliminary examination momentarily. Let me just say something else. I received, and I don't know that I sent them off to the people, but I received on yesterday 2 letters, communications from Mr. Jolly. He said he sent a copy to the prosecutor's office.
And I was going to say, Your Honor, I received a Teams message this morning from Miss Purdue, Tammy Purdue from our office, that we did receive those in the mail this morning. They hadn't been uploaded to the file yet, but there was a demand for jury trial and request for speedy trial.
Yes, so that is what I received, and a 12-person jury trial rather than a 6-person jury trial, if possible. That would, if this case is bound over, be will be dealt with by Judge Slay in that. And further, I would indicate that the delays in these proceedings, and I'm not trying to blame anybody for it necessarily, but the delays in these proceedings are really attributable to the defendant, given that he wished not to participate or come up and participate in the proceedings. So, this is the exam. Mr. Jolly, I do also have to inform you, since you are representing yourself, and I've advised you previously of the perils of representing yourself, and that it can be fraught with some difficulty. You are charged with the offense of assault on an employee or a prison employee or an employee of a place of confinement. You do understand that charge, sir, correct? All right. That is a felony punishable by up to 5 years incarceration and a $2,500 fine plus court costs. You understand that, sir? All right. You're here representing yourself. You'll be held to the same standards as I would hold an attorney. I will not show you any favoritism or anything along those lines. You will be presumed to understand court procedure and the rules. You understand that, sir? All right. So you are also entitled to be represented by counsel. And if you make the request of the court to be represented by counsel at any point in the proceeding, the court will have an attorney to represent you. So, Mr. Jolly, I will ask you now, prior to us proceeding, do you wish to be represented by an attorney on this, sir? Okay, you want to proceed still on your own? And you understand my admonition or my caution to you? You understand that, sir? All right, very good. And we'll proceed.
And Your Honor, just a couple things for the sake of the record. Obviously, we're recording this. I know there's a video and we're all looking at it, but other than the question about having a counsel, the defendant nodded affirmatively to all of the court's questions. He then nodded in the negative with response to requesting an attorney. I just want to make sure that the record is clear to that.
Yes, and that is what the court's understanding.
And I would just further add, when we were last up on June the 26th and this matter was set for an exam, I did advise the court that a fresh or a clean copy of all of the police reports would be sent via interdepartmental mail to the defendant in the jail. And I did do that. I believe it was the following week, but that was sent in the interdepartmental mail by myself, a clean copy to Mr. Jolly. I just want the record to be clear as to that effect as well.
All right. And you received that, Mr. Jolly? So have you received any of the police reports in this case? So you've not received any of the evidence or anything like that? Okay, you put your hands up. Does that mean you don't know if you received it or you did not? Okay, let's do it this way, because you're nodding and you're using your head to respond to my questions. So I'll ask it really simple. Did you receive any of the discovery of police reports? All right, you're shaking your head no. So you have no information regarding this case? Okay.
For what it's worth, Your Honor, when I actually spoke with Miss Kyriak and Rulli from the Public Defender's Office and asked her if I'm going to send something to an inmate, can I do it via interdepartmental mail? And what she told me was yes, put WCJ on the letters that we send throughout the department with the inmate's name, and it should get there. And that's what I did.
And I'm not familiar enough with this process, but is there a way to track whether or not it's been received and delivered to the inmate? Mr. Allen, are you aware of that?
There's two bail.
Pardon?
Bail visiting officer, whoever does that, they would know. Up front.
Okay. Mr. Jolly, if I, rather than do this by Zoom, if I give a new date, could you promise me to come up to the courtroom so that we can make sure you have all of the stuff you need? You don't want to come up to the courtroom. Okay, so here's what I'm going to do. Much to my chagrin, and I do apologize to Mr. Apple because he's been here all day waiting for this, but this is the last thing I thought.
Well, in my thought, Your Honor, what I could do is speak with perhaps Commander Shipakasi or Lieutenant Arnett or someone and hand deliver it to them and have them hand deliver it to Mr. Jolly. And I could even prepare a proof of service.
Correct.
To that effect.
That's the part that I was thinking, so that he could do that. Yes, I see your indication of a speedy trial, but I also have to make sure that it is fair. So that is why I hesitate in proceeding today. So what I'm gonna do, give me my earliest day after it's the 4th. Who do I have on the 4th?
On the 4th,
That's where I sat.
that's where you set Pelfrey's 5 cases. Anyone?
And I know we also are here on Mr. Franklin on the 11th at 1 o'clock. I don't expect that to take longer than
Franklin?
Mr. Franklin is probably an hour and a half, 2 hours maximum in total.
All right, but we said that was in the afternoon,
That was in the afternoon on the 11th.
because I have jury selection if I pick one.
Jury selection only. Jury before that.
Okay, so what would, just to get everybody's input, I don't know where Mr. Jolly will be. Sir, would the 4th or the 11th be better for you? And I apologize,
Either or.
Would they both be in the afternoon or morning or either or?
So on the 4th, we've got those
5 in the morning, but I do this first if we put it there.
That, I mean, correct me if I'm wrong, Mr. Apple, but if we did it first thing in the morning on the 4th, would that be better because you get off work at 7 a.m.?
Yeah.
Let's
do that then. All right, the discovery packet will be delivered. We'll make sure of that. We'll have a proof of service. I'll adjourn this to my next available date, the preliminary examination. I will adjourn it to August 4th, 2025, 9 a.m. for me. And again, my apologies to the witness, Mr. Apple, in this case. I did not anticipate.
And again, just so the record's clear, is the court finding good cause for this adjournment?
Yes, I am adjourning this, finding good cause, because the defendant at least is indicating that he does not have discovery, although I believe it was sent. I can't verify that it was.
And I will work with jail staff to ensure that it is hand delivered along with the proof of service, which I will send to the court once I receive it back.
All right, very good. Thank you, folks. Thank you, Mr. Jolly.